We're starting strong, trial date locked in. But the judge is already hinting that some big rulings are coming. One decision could completely shift the direction of this case.
Good morning, you're near Benur.
Yes, ma'am.
And Mr. Benur's case is set for trial. This is 22-40828, Monday, the 1st of December. What is the announcement?
Judge, we're ready.
State your name.
With regard to the issues that we began discussion of, and I gave some time for Mr. Gertz to be able to reach out with investigation on other complaining witnesses, has all that been taken care of?
From our standpoint, Judge, we've had no ability to get anyone to speak with us.
Okay.
So that's their choice,
Sure.
obviously, but we've made the effort to have that done.
So what I need to do then is, prior to that Monday, make a ruling. We probably need just a little bit of time for them to.
I think one of the challenges I have, Judge, is I'd like to, what we had, just my recollection is what we had last time was essentially a proffer by an investigator, just proffering what other people said.
Right.
But I don't feel like we have the details, sort of police report level details from any of these allegations, if you will, so I guess.
No written statements. That means less concrete evidence for the defense to challenge and more reliance on verbal accounts. In a courtroom, missing documentation opens the door for reasonable doubt.
I just feels like that would be discoverable, whatever the state has in their possession about these
Have
interviews.
there been any?
There are no written statements, Judge. We made, in fact, I don't know that we were even under an obligation to give as much detail as we gave. We gave him notice of these witnesses, that they exist, and the nature of what their testimony might be. But the short answer, Your Honor, is there's been no written statements.
And have they talked with just investigators, or have they talked with detectives from other agencies, or just within your office?
Just within our office,
Okay.
to the extent that I'm aware of, Judge.
Okay, so there aren't any police reports or anything like
Not
that?
that I'm aware of.
I think what I'm going to need to do, and I know I made some pretty detailed notes when we were here before, is make obviously the ruling on which, if any or all, I'm going to allow. And so, there's my notes, look at that. I don't know that I need, if there is no other. So there were 4, correct? We used initials. We had an initial of SM, which was a 2000 case, tummy tuck. There was some pretty detailed information that was given on that one. There was MN, which was a 1992 sinus issue with some other issues that came to light that time. And then we had a TK that I think had become now a TR from 2022.
Multiple witnesses, but barely any follow-up and 0 police reports? A jury could easily wonder why these interviews weren't fully pursued if their testimony is so important.
Also some details about that one. And then an RD from 2015 was a tummy tuck. And then one more, but that one hadn't been contacted back. In RL, is there any notation that one is so? Okay.
We've not had any subsequent contact with RL.
All right. So if there aren't any other police reports, and do you want time early one day this week to actually have an argument hearing? Do y'all just want me to make my decision based on what I have?
I think it'd probably be better to do it written by submission and let the court rule on it next week sometime.
Okay.
I don't have anything additional to add. I'm okay with the court just making a ruling.
Is that your phone?
The answer is yes. I'm okay with the court just making a ruling without any additional argument. Just make sure it's all completely off.
Take it out, make sure.
Yes.
Okay, so what I'd like is if you guys will get that, anything written, I think, Mr.
I think I gave
You
copies.
already did, I'm pretty sure. And so what I'll do, if you want to, have it,
The judge wants a ruling done fast, and pressure like this can reveal weaknesses. Will the state meet expectations? Or does the defense gain leverage from the rush?
anything to add to yours, you're welcome to do that. And then if you just want to do a response in writing, I would really like that, if possible by Thursday, or you in trial this week, by Thursday of this week.
I'm not in trial now this week.
I'd like to make that ruling before the end of this week so that you all know while we're off next week what to be preparing for. I anticipate this will be the number one trial, obviously. I think we've talked about that and making it a special setting because of the age and the fact that we've already gone through it. So I want to make that ruling by Friday. So I'll be around. Obviously, I'm in trial, and I'll make that and give it to you guys by email or by an order. Okay?
Yes, Judge.
Judge, the court has already ruled previously in a previous hearing subsequent to the trial that the court would allow this case to be off of YouTube. We just reminded the court of that decision that I believe was made a while back, and asked the court to do that once we begin trial on the 1st.
Did I?
I don't recall that, Judge.
Why would I have done that?
I believe.
I think
The defense is saying this case isn't special. That's a strategy. If it's treated like a standard case, less reason to restrict courtroom access on YouTube. More transparency means more scrutiny.
I mean, you may have asked for it, but I don't remember saying that I would. I think if the complaining witnesses have an issue, then I would be, if I recall, I don't remember, I thought it was this case where I talked about potentially during certain testimony, blurring it out or blacking out certain things, but I don't, if you want to do something, a brief in writing, a short, something about what your request is and why, I don't recall actually or saying that I for sure would not do that. That doesn't, I remember maybe having the discussion, but I don't remember saying for sure I would.
And just I think the facts for this case are distinguishable from the typical case.
Sure. I mean, I never put child
Yeah,
cases
okay.
on, and typically I primarily leave it up to a complaining witness or something like that, who's disclosing, private certain information. But I will take what you have to say into consideration. If you will also reach out to, I think the complaining witness, I mean, we had it on last time. If she's still okay with that, at least just shoot me an email and let me know, and then put whatever you need in writing, and then I'll make that decision when it gets a little closer.
Okay.
Anything
Thank you.
else that you guys know of that we will need to address pre-trial on this one?
Not from the state judge.
Okay, all right, then I'll make that ruling again on those additional witnesses by Friday.
Okay.
All right, stay in touch with Mr. Gertz. He'll let you know when you need to be back. And then, Mr. Gertz, you have a Jonathan Zcaff. All right, so you're Jonathan Zcaff. And this is 24 DCCR 2348. Mr. Zcaff's case is set for trial also to begin with jury selection on December the 1st. Announcement.
It's pleading to a lesser included.
Oh, it's right here. Gotcha. Hold on. Hold on. I need to look at too many things. DWS second. Okay. Let me get that pulled up. Mr. Gertz, will your client waive the formal reading of the indictment?
You will, Judge.
Mr. Galvan.
All right, Mr. Zcaff, the state has elected to proceed So it would be on the April 10th, our date, and then just one prior.
One
And
priors, Judge.
so it would be paragraph 1 and 2, correct?
Yes.
So it's not really counts. Okay. So the state's elected to proceed on paragraph 1 and 2. It alleges that you committed the offense of driving while intoxicated April 10th of 2024. The indictment further alleges in paragraph 2 that you were previously convicted of driving while intoxicated January 16th of 2019. And how do you plead to that charge? And is that prior conviction true? Did you enter your plea of guilty and true freely and voluntarily? And because you did what they charged you with.
The judge reminds everyone who really holds the power, even if both sides agree, she can tighten probation conditions at any moment. That's why plea deals are never just routine.